Hello and welcome to another episode of A Question of Law. This is City TV's legal education program, basically designed to break down the law and give you a bit of education as far as the activities that we engage in our daily lives, and the things that happen around us. Well, the show is interactive, and so use the hashtag A Question of Law. The WhatsApp line is 0550-585-832. We're going to take a short break. We'll come back and I'll introduce my guest to you, and we will delve right into those conversations. All right, welcome back. And my guests are here seated. I have with me Kwesi Kelly Delata, who is a legal practitioner, private legal practitioner. And I also have Albert Kwashiga, who is also a private legal practitioner, as well as a law lecturer at the UPSA School of Law. Gentlemen, you're welcome.
Thank you. Thank you.
All right. So before we delve into the conversation for today, and of course today's conversation, we're going to be talking a bit about the issues in Parliament, the happenings, the issue of Speaker versus Deputy Speaker and all of that. They went to court to go and, get a clearance, a clear judgment by the Supreme Court on what it is that should be happening, an interpretation of the Constitution. Well, we're going to find out all the ins and outs of that conversation there. All right. But before we get into that, let's just find out, the recent happenings in Parliament. The three MPs are being dragged to the Privileges Committee. I know that sometimes it's happened before, that some members have been taken to the Privileges Committee before, but has this three seems like a precedent? I don't know what your comments are regarding this.
Yes, Kweku, I have no recollection that members of Parliament have been hauled before the Privileges Committee of Parliament for absenting themselves for 15 days. In fact, this is novel. And I think that we have to congratulate Parliament that has decided to apply the law.
Its own laws, yes.
And I think that this is just a reminder of the Supreme Court decision we're just about to discuss. The Parliament is not a law unto itself. In fact, we should come to a position or a point where important institutions or powerful institutions of state, respect the law. And I'm looking forward to how Parliament, especially the Privileges Committee of Parliament, deals with this particular matter. Whichever way it deals with it, it will send a very strong signal to the rest of us. And I'm talking about the rest of the citizenry, that nobody is above the law. And that if a member of Parliament is caught as having violated the law, the important sanctions allowed by the Constitution and other laws will be applied to them. Albert.
Yeah, so Kweku, this Parliament in particular is an interesting one. Right from the word go, it's shown that it's going to be one tough Parliament. Yeah, because it's a hung one, and numbers are extremely crucial. As things stand, it looks like both parties have, equal numbers in Parliament, and so I think there's a lot of maneuvering, to one way or the other, lessen the numbers of one party or the other. Yeah. And I think that's basically what's going on. There are cases in court, and there are also issues of absenteeism coming up at this particular time. And as my friend has said, I also do not have any personal recollection of people having been taken to the Privileges Committee because of absenteeism. Okay. But I know that people have gone there on other matters. Okay. And so we see how this matter will be dealt with. Parliament itself has insisted that it's the master of its own rules all the time. Yeah. And so we see how they handle this matter. And don't forget that this matter has implications for the Constitution also. Apart from their own standing over this, whether a member absents himself or herself for a number of days is a matter of constitutional provision. Yeah. And so we it's my expectation that Parliament would deal with these matters more in their own circles, because if we are not careful and this is not looked at carefully, eventually Parliament will be opening up itself for more Supreme Court intrusion into their space. And so I think that we see how the matter will develop and how Parliament will handle it in its own way.
Yes, so I believe that this is a developing matter.
Yes.
We'll get opportunity to discuss it in full, to flesh out all of the political and even legal angles to this matter. It's interesting that on the floor of Parliament yesterday, there was disagreement between the minority and the Speaker of Parliament about what procedure to adopt. And the procedure to adapt is very, very important, because the right procedure is not adapted. The productive consequence of this process, which we're all hailing, may turn out to be invalid after all. And I'm sure that if we have opportunity to discuss this as our next program, I'm sure that we'll flesh out all of the angles to educate our listeners.
So let's go back to this issue, because when Parliament makes the argument that it's master of its own procedures, the Constitution, however, is ruler over all, right?
Yes.
And so we go to the Supreme Court, and I guess that's the reason why we go to the Supreme Court in the first place.
Yes.
So if we can get into this issue first of all, so I know Richard Sky took the matter to the Supreme Court. Justice Abdulai did the same. Let's flesh out this issue, right? Both issues went to court. What are the issues about? What did they go and seek? And so on. And then let's get some education.
Well, I think in respect of Justice Abdulai, Justice Abdulai's matter against the Attorney General, it was heavily planked on the historic events between the 26th and the 30th of November 2001. As you recall, on the 26th of September, the budget was rejected.
Yes.
The majority held the view that there was no quorum. There were just 137 members of Parliament when the budget was rejected, and so therefore it was unconstitutional. And then on the 30th, Parliament reconvened, and the budget rejection was reversed by the majority, 138. And the reason was 138 members of Parliament at the time that crucial decision was taken was because the first Deputy Speaker, who happened to be in the Speaker's seat, joined. As you know, Article 104(1) of the Constitution requires that for decision making we should have no less than half the members of Parliament seated to make the decision valid. So then the minority began to question the decision by the first Deputy Speaker to vote. Of the view, the minority's view is that the first Deputy Speaker, once is seated as a Speaker, moderating proceedings of the House, should not ordinarily be allowed to vote. And to count himself as quorum for purposes of voting. And so Justice Abdulai, I'm sure, was interested in the development and if you like, a political and constitutional stalemate, and so decided to test the matter in the Supreme Court. And so that's the judgment we had in Justice Abdulai and the Attorney General. I'm sure that very soon we'll flesh out different aspects of that judgment.
Yes, basically. I mean, so I think he's given you the background, the events which led to justice going to the Supreme Court. And you see, as a citizen of this country, each and every one of us has a duty to uphold the Constitution. When you observe that something is happening or there's a conduct which might impeach or undermine provisions of the Constitution, you have a duty to take up the matter. I believe it was in that capacity that Justice and probably Richard Sky decided to go to the court to ask a few questions to the Supreme Court, whether or not those events which took place on the 26th and the 30th of November 2021 are matters which are not in violation of the Constitution. And so I think it was a good opportunity for us to deal with this matter. Now, because interestingly, this matter, for instance, had not really come up like this before. they have never really come up. So it brought up interesting issues, and that's one interesting thing about law. I mean, sometimes there are angles you never think about, but people bring it up, and so I think it was a good thing. And the court pronounced on it. So when we go into the details,
let's go into the details.
So Justice Abdulai was exercising the constitutional authority given to all citizens of the Republic under Article 2 of our Constitution, that if you find something going wrong, and to be more specific, if you find that anybody is violating the Constitution, any of the organs of government are violating the Constitution, being the executive or the legislature are violating the Constitution.
Even the judiciary.
At the judiciary. You have the power, you have the right, the authority to seek an interpretation of what you allege to be a violation of the Constitution for the Supreme Court to declare.
Okay. Let me just ask the importance of this particular thing, because we live in a society where the big man is never wrong, right? So how important is this thing for us to be able to test this all the way up to the Supreme Court?
Yes, I think that previously we didn't have any such clear provisions in our Constitution. I think that the 1979 Constitution, the 1992 Constitution make it very clear that every citizen has got a duty to protect the sanctity of our Constitution. I mean, you remember that, previously, if there was an unconstitutional overthrow of the government, and you attempted to restore the Constitution, you face sanctions. I mean, the reason why a very prominent citizen of our republic, is Kwame Pino, never became president of the Republic of Ghana was because he was found by a court of law to have attempted to overthrow a government, even though that government itself would be considered legitimate in the constitutional sense. So the provisions of Article 2 are very, very welcoming. That any citizen, you and me, Kweku, if we felt that any of the organs of government are engaged in an action which is in violation of the 1992 Constitution, we could go to court to get them to stop that. And I think that is a very refreshing constitutional development. And Justice Abdulai took advantage of it. Justice Abdulai is not the only person who is taking advantage of Article 2 of our Constitution, but several other citizens have taken advantage of that, and it's led to the development of our constitutional jurisprudence. Yes.
So let me just add something. Yes. You see, so it's an important provision and it's an important right given to citizens, okay? But before you exercise that right, you must really be careful. Because there are times when you go to the Supreme Court because you are probably going for interpretation or an enforcement, to invoke its enforcement jurisdiction. And the Supreme Court will tell you that this matter doesn't raise issues of interpretation. The issues are clear. And so you should just go out. So they throw your case out.
Something like that
a number of those cases. And so it's very important, and when people have successfully gone through that phase, we appreciate what they have done, because it's not every case that has issues of interpretation. And so usually provisions of the Constitution may be subject to more than one meaning. So for instance, my good friend may take one view of a provision and I may take another view. Once it happens that way, there is an issue for the Supreme Court to come in to decide which of the views align with modern realities and serves the purpose of the Republic. So this is the context within which people go to court when it comes to some of these matters.
Okay.
And Kwegu, I think the Supreme Court has set a standard for invoking its original jurisdiction when it comes to interpretation of the Constitution. And I think that those standards are laid out in the important decisions of ex parte Corsa. And I think Osei Ababu against the National Media Commission and Apenteng. I mean, the standards to meet, to invoke the original jurisdiction of the Supreme Court as the diviner of the Constitution are there. So if you are coming under Article 2 of the Constitution as a citizen of the Republic, those standards have to be met. First and foremost, it must be that you are alleging that a particular provision of the Constitution is unclear. Number two, that two persons have taken a different view of the interpretative meaning of one provision of the Constitution. Those are some of the considerations. That is not clear, or that there's actually no provision at all for an important development to be resolved.
Okay.
So in that case, we'll call on the Supreme Court to use all of the interpretative tools to try to divine the meaning relative to that important development.
Okay.
Yes.
So there's a headline here on citynewsroom.com. It says, your case on the 2022 budget approval is moot. Supreme Court to Richard Sky. What are the similarities between the two cases? What reliefs did they go to seek? And why is the Supreme Court saying that his case is moot?
All right, so if I recall it was Richard Sky who went first to the Supreme Court, is that correct?
Yes.
So I've been thinking of how come Justice Abdulai's case overtook the determination. I've never really gotten the reason why, but probably one of the cases has moved faster. Okay, but I think that Richard Sky's case and Justice Abdulai's case are all cases which arose from the events of 26th and 30th of November 2021. Okay, and the issues are not different. In fact, if the issues were different, the Supreme Court would not have said that Richard Sky's case was moot. Because once the same issues have been raised and it's been determined, there's no need wasting man hours and resources to determine it again. All right. Okay. So basically, that's what it is. But what were the issues? I think, as has been said, recounted by my friend, my colleague, I think on the 26th of November, budget was rejected by about 37 members of Parliament, and on the 30th, that rejection was undone, and the budget was deemed to have been approved as a result by 138 members. And as he said, the numbers would ordinarily not have been 138, it would have been 137. But the speaker, the deputy speaker who was presiding at the time, decided that for purposes of decision under Article 104, he would count himself as forming quorum for decision making. Okay. He counted himself, but from the fact he did not vote. But the quorum was formed, and then a decision was actually taken. Yeah. And the minority believed that this was not a proper process. But it's the reason why Sky and Abdulai went to the court. And the court determined the issues. Basically, the court came to the conclusion that, and the court went through a number of analysis, and they touched on a number of things in the judgment, okay? But eventually, the court took the view that in terms of 104, a person presiding as a deputy, right, in the absence of the speaker, had the right to count himself as forming quorum. It's because under 104, the quorum requirement is at least half of the all members of Parliament. And that should ordinarily be 137.5. But you won't have that. So it's 138. Okay, so 138. So basically, the minority takes that view that it was not right for him to have counted himself, but he did, and the court affirmed. So as we sit here, it is now precedent that when it comes to Article 104 quorum, the one who is presiding as a deputy who is presiding can count himself for purposes of quorum, and a decision can be taken based on that.
So I guess the question that I have is about the quorum for business vis-a-vis the quorum for decision making.
Excellent.
I know that the quorum for business is supposed to be like 1/3.
Yes,
is that the case?
Correctly. And the 102.
Excuse me. And so how does this then? How do we move forward? Because I think that there are still questions that remain. Even though the Supreme Court has sat on this, give us a bit more explanation as to how we move forward.
So the quorum requirements in the Constitution relative to parliamentary business, we've seen a a contest between the two provisions, and talking about Article 102 of the Constitution and Article 104. Article 102 is the one that deals with quorum for business. In other words, before Parliament can start proceedings for the day, how many members of Parliament should be present before Parliament can validly commence business for the day. And the provisions of that is that at least one third of the members of Parliament. But when it comes to decision making, that's regulated by Article 104 of the Constitution, and that basically says that it must be at least half of the members of Parliament before a decision can be so validly taken. And this is what the judgment of the Supreme Court in Justice Abdulai and the Attorney General is about. I mean, the Supreme Court basically said that the quorum requirements are different. And they are different the way they are because of the different importance that the law attaches to the different stages of parliamentary business. The Supreme Court is of the view that when it comes to forming a quorum for business in Parliament, because it's merely deliberative, merely members of Parliament would make comments or make speeches about development and so on and so forth. That is not of a greater importance than the quorum which is required for voting. So in the view of the Supreme Court, when it comes to deliberations on the floor of Parliament, because no legal consequences per se attach to that deliberative function of Parliament, the quorum requirement is made much, much less stringent than the quorum requirement for when it comes to decision making, such as taking a vote. If you vote on a matter, it has far more reaching legal consequences than if we're just talking about a matter. So that is why the Supreme Court is of the view that when it comes to Article 104, the quorum requirements are stricter. Okay, but the key question which the court had to answer was whether or not, for purposes of satisfying the quorum requirement in Article 104 of the Constitution, it was necessary to count a first deputy speaker or any of the deputy speakers who are sitting or presiding over parliamentary business for the day. And I think that's a key question, that's a key issue from this decision. As we have seen, the court has decided that for purposes of forming a quorum under 104 of the Constitution, it doesn't offend the Constitution if a deputy speaker who is presiding is counted for purposes of forming the quorum to take a decision on the floor of Parliament. And as you have seen, this has generated a lot of controversy, not just in the academia, but ordinary people like you and me are asking questions about, well, how can it be that, the deputy speaker who is presiding over parliamentary business cannot be counted for purposes of commencing parliamentary business, but then can be counted for purposes of taking decisions on the floor of Parliament. And I think that these are all legitimate concerns that have been raised by people. I have refrained from publicly making my views on the matter known, and I was telling Albert that this is not a program for us to come and critique the judgment per se, but it's just to educate people about what the reliefs are, what the Supreme Court thought about the release and the conclusions that the Supreme Court came to. But I can assure you that there are very good grounds in law to say that the Supreme Court was very wrong in how it determined the question of whether or not a deputy speaker speaking or sitting can be counted for purposes of quorum under Article 104 of the Constitution.
All right, quick. So I think Kelly said a lot. And when we're coming in, actually, it was an issue we needed to be clear about. We didn't want to. We have problems with the decision of the Supreme Court. I think the Supreme Court was wrong on grounds of law. And it's my view on the matter. For instance, I think at best, the decision was speculative in a lot of ways without proper justification in law. So, for instance, the Supreme Court tries to distinguish between a voting a voting quorum and a non-voting quorum. The voting quorum is what you have in 104.
Yes.
And then the non-voting quorum is what you have in 102. The Supreme Court proceeds, for instance, by saying that because under 102, Parliament's function over there is only deliberative, is not as important as taking decisions. And I'm asking myself, who says that deliberation is less important than decision making? Because if you don't deliberate, there's no way you can take a decision. Do you get the point? And the Supreme Court's justification is that the framers must have thought, as the framers of the Constitution must have thought that 104 was more important than 102. And I'm asking, which framers? If you look at the judgment, the Supreme Court did not refer to any proceedings, discussions of the Consultative Assembly, those who wrote the Constitution, because these matters would have come up or not at all. So the Supreme Court made general references to the framers without pointing us to whether or not this issue had even come up in the past or it was discussed in 92 or thereabout.
Yeah.
And there are many other grounds, for instance. Supreme Court says that if the framers thought that, they wanted to exclude a person presiding under 104, they would have said it clearly.
Yeah.
As they said in 102. 102, it says that apart from the person presiding, the quorum is 1/3. Is that what it is? So the one who's presiding has been excluded expressly. That's under 102. And then they are saying that, well, if the framers wanted to exclude the person presiding, they would have said the same thing under 104. Is that not the case? And I'm saying that, which framers again? I mean, in such matters, in other jurisdictions, for instance, in the US, the courts would go into legislative history. They will go back into what happened in the debates and point it out. It is possible that when the framers were drafting the Constitution, this issue never came up. They didn't even think about it.
Yeah. So
the fact that it's been written in black and white does not mean that they thought about it and decided to do that. It probably could be an omission or something like that. So there are a lot of justifications in this judgment which I find quite problematic. But I can say that this decision provides a basis for learning and for students of law who are taking constitutional law, any other course. This decision brings up a lot of things. Okay. So the key issues have been addressed.
Yeah.
The Supreme Court has decided, and that is going to be precedent going forward.
Yeah.
You get it? And the Supreme Court has also moved on to discuss issues of parliamentary sovereignty as against constitutional supremacy. All those things have been discussed in the case.
So I think I want to delve a little bit into that when we come back after this short break. Don't go anywhere.
Very well.
The question of law will continue shortly.
City TV is live on DSTV. Go to channel 363. On GoTV, access City TV on channel 182. On a digital TV, please press the menu button on the remote control and run a new search on your TV. Take note that without an antenna, you cannot access City TV on your television. City TV can be accessed on a free-to-air digital box like the GoTV and StarTimes box. City TV, it's your world.
All right, welcome back. It's still a question of law. Show is interactive. It's a hashtag question of law on all social media platforms. The WhatsApp line is 0550-585832. We definitely want to hear from you and your thoughts regarding all the conversations that we're having here. But here's the question. Parliament is master of its own procedures, but the Constitution is the boss of all.
Really, it's the boss. It's the boss.
That's interesting. I mean, Kwaku, you know that's the reason why the Supreme Court in its judgment in this matter rejected the political questions doctrine.
Okay.
Because the Supreme Court basically says that whatever happens in Parliament, the rules and procedures of Parliament, as long as they violate any provisions of the Constitution, the Supreme Court has got the jurisdiction or the authority to declare it so. So that's very interesting in many ways. But as you would see, the Supreme Court was willing to declare absolutely the Parliament is the master of his own business.
Yeah.
But for the fact that some of the matters that this matter implicated, and I'm talking of the matter which Justice Abdulai took to court, the matter implicated meaning of some provisions of the Constitution. For example, Article 102, Article 104 of the Constitution. The Supreme Court was prepared to grant Parliament that opportunity to be master of his own business. But for the fact that the matters which this particular case implicated involve interpretation of two important articles of the Constitution, namely Article 102
and 104.
And Article 104. So that doesn't sound to me as a round rejection of the political questions doctrine, because as you can see from what I've said, if the Supreme Court had found that the question was purely about the procedures adopted by Parliament to do business, if it was just about that, they were prepared to grant Parliament that status as an institution that can have mastery of his own business. But for the fact that this was also about some articles of the Constitution that the parties thought was relevant for determining the original issue before the court. Yes.
That's true. So that's what I made the point earlier on, that if Parliament is unable to resolve some of these issues in Parliament, then the Supreme Court would have more intrusion into the space of the things that actually happen in Parliament. You know, so as far as Parliament is concerned, you know, there are a number of things that go on over there. I don't think that I don't have a recollection of any situation where the Speaker has taken a decision where it's a member has taken that decision to the Supreme Court. I don't know of that situation. So for a very long time, it's always been an in-house thing. But as I said, this time around is about numbers, and there's a lot of maneuvering and all that. So it's important for people to seek clarification, and the Supreme Court has the power to do that, because it will be very troubling for anybody to think that the Ghanaian Parliament was like the UK Parliament of old. It will be very troubling. It's because the UK Parliament, the UK Parliament was such that they were a law unto themselves.
Okay.
And no court in the UK could question any law passed by Parliament. And this is what it is. Because the UK cannot be spoken of as having a single formal constitution like our own. Because we have a document in which we are told under Article 1, that the Constitution is the supreme law of the land.
Yeah.
You won't find that in the UK.
Okay.
And so once you have a declaration like that, there's a standard of measurement of conduct in our scenario. You get it? So, I mean, I'm not sure anybody's ever thinking that Parliament is thinking that it is sovereign. Parliament at best is autonomous when it comes to its procedures. But in terms of sovereignty, it will not work. The Constitution trumps every other, law or every other institution in the Republic of Ghana. But more importantly, in this decision, I think that the Supreme Court focused more on in accepting that the Deputy Speaker could count himself as quorum.
Yes.
They went heavy on the issue of representation of the people.
Yes.
Because, I mean, people voted for an MP.
Yes.
So at any point in time, he must contribute. He must take part in proceedings.
Yeah.
And be able to be counted. But my question is, in the Constitution itself, there are other places where MPs would have been prevented from voting. And that's also representation. So in those scenarios where the Constitution itself has made it impossible for you to vote, what do you say? It's about you are still being denied representation. Is that not
Can
it?
you give us an example of that?
Yeah, so I mean, in respect of this particular matter, I mean, the point is that if you even look at article, I think there's a provision in the Constitution which says that when it comes to contracts, with government, in which a member of parliament may be a partner in the firm going to the contract with government, you have to disclose your interest and not participate in voting. That's one scenario in which the Constitution itself takes away the right to vote. Now, in another scenario, under 102, it says that apart from the person presiding, so if he's a deputy, then he must be a member of parliament. At that point, he's also been denied representation, is that not it? By the Constitution itself. So the heavy reliance on the issue of representation and all that, for me, was really neither here nor there, because in other places, there's a denial representation.
But okay,
Yes.
okay. So I mean,
yeah.
I can't speak for either side, but the way I see it as a layperson, I mean, someone was arguing with me on this matter and said that, well, it's a choice to accept the position of deputy speaker or not. So if you accept it, then you also understand that there are consequences. That if you accept it, one day you may sit in the seat of the speaker, which means your people should also understand that they may have to relinquish in that moment the capacity to take decisions.
Yes, I've heard that argument too, and I think that argument makes a lot of sense. But this is how the Supreme Court treats it. If like there's a direct response of the Supreme Court to that argument. You know that Article 1042 basically says that the Speaker has neither original nor casting vote.
Yeah.
That article is very clear on the subject. Now, the Supreme Court says that the Speaker, in that article, Article 1042, and the Speaker, as it will be if any of the deputies was to be sitting as Speaker of Parliament, overseeing parliamentary business, they said that it's not the same. That's how the Supreme Court treats it. It said that the Speaker in 1042 and the Speaker presiding, if he was, not the Speaker, but any of the deputies, says that it's not exactly the same. Now, this is where Albert has lured me into doing some form of criticism. And
it's necessary to, at least.
And I have a little difficulty with that. And I was happy that the Supreme Court itself cites Article 295(2) of the Constitution. And
yes.
Albert, if I may.
Yeah, you may refer to.
Article
295.
Yes.
295(2).
I can help you. Yes. 2952.
Yes. 295(2). Yes.
Okay.
Yeah. So you see, it's so that's
so
like,
it says. If you may permit me to read
2952. Further.
It says, in this Constitution and in any other law, a reference to the holder of an office by the term designating his office shall, unless the context otherwise requires, be construed as including a reference to a person for the time being lawfully acting or performing the functions of that office. So basically, this is what the Constitution says in Article 295(2), that if you were not a substantive person occupying the position, but in the circumstances that we find ourselves, where any of the deputy speakers will be sitting in the speaker's seat, it says that all the privileges of that office, all the powers of that office would be manifest in that person. But unfortunately, the Supreme Court decided that the context is not the same. I'm wondering what other context we're talking about. But this is a deputy speaker of parliament who is sitting and exercising all the powers, And you see, in many other countries, and I'm very happy that towards the end of the judgment, the Supreme Court has done some comparative analysis. comparative, constitutional law, if you like it. Because he cited the examples from Canada, he cited the examples from the UK, he cited examples from the USA and Australia. And happily makes the point that in these countries, because of concerns for neutrality, especially political neutrality of the Speaker of Parliament, even though in these countries the speakers are elected, they're participating in the decision-making process. Their participation in the decision-making process is just limited to a vote to cast, casting vote.
Yeah.
Okay, so in all of these countries that the Supreme Court talks about,
you can then activate
there is concern that the person at any point in time who is sitting as the Speaker of Parliament must be neutral, at least must be seen to be neutral in the eyes of all the other members of Parliament and the nation. And I was surprised that this important consideration did not influence the Supreme Court to strike a different path from the path which they struck. Because I think that the considerations which have allowed those other countries in which the Speaker is elected, but his participation in the decision-making process is limited to the casting vote, is as relevant in Ghana today as at any other time in our history. Because we need to be sure of the political neutrality of the person who is sitting as a Speaker of the House. All sides of the House need to see the Speaker in that light, that this person is neutral, especially when it comes to decision-making process.
I mean, at least manifestly, he must be seen to be neutral.
And the way to ensure that is because we can never be sure that the person sitting as the Speaker at any point in time will exhibit the neutrality, which is ideal for political decision-making. Then
I guess
that is why.
Go on.
Yes, because we are not sure. That is why it's important that at least it's prevented from voting when it comes to decision-making. And I thought that the Supreme Court missed the opportunity to reassert the political neutrality of any person who is sitting as the Speaker of Parliament at any point.
Before you come in, let me just say, as I said, I don't envy the Supreme Court at all. And the courts, the judges, they do a lot of work. Trust me. I mean, how many pages of judgments are there? 29. Some are 50, some are 60. I mean, so there's a lot of work that goes on over there. And we appreciate what they do. But I think it's also proper that when decisions come out, for the sake of education, we are able to touch on a few things. That before you come, just briefly, when it comes to interpretation of the Constitution or laws or even documents, there are rules of interpretation. Okay? Rules of interpretation. And depending on the attitude of the state, you decide what approach to choose. I mean, it is our approach in this country that we are more purposive in our interpretation. In other words, we take a liberal and progressive view of the Constitution. We read the Constitution to give it life, to deal with current realities. Okay? Now, my view is this. In this judgment, for instance, it's not the Supreme Court referenced a lot of cases where the approach of being progressive, purposive was used. But I think it turned out applying a very strict approach to the interpretation of the provision. And I'm saying this because if the court were applying a more progressive view of interpretation, it would not have concluded, for instance, that under 104, the person presiding is not excluded from forming a quorum. Because look at 102, it comes before 104, okay? And it says that you are excluded. If we had been more purposive and more progressive, you would have said, if 102 says a person presiding is excluded, then under 104, it follows that it's excluded. But that was not the way. And so the court decided to use what we call maxims. Maxims are like aids they are helps to interpretation. They are not rules of interpretation. The court relied on that and used what they call the expressio unis exclusio rule, that an express mention of a thing, right, means that those not expressly mentioned are excluded. So if the Constitution says that in one breath you exclude a person presiding, then in the other breath when they didn't say that, they intended not to say that. and all that. So there are a lot of interesting angles to this, and I think that for the sake of this,
I guess depending on where you sit, you view things different ways and so on. But the Supreme Court has made their ruling. I'm sure people are going to go back to seek, further interpretation and so on. And not everybody agrees with what the Supreme Court has ruled, but some people also agree with the Supreme Court as well. So a very interesting conversation, a very interesting time in which we live. We'll take a short break, and up next will be the docket.
City TV is live on DSTV. Go to channel 363. On GoTV, access City TV on channel 182. On a digital TV, please press the menu button on the remote control and run a new search on your TV. Take note that without an antenna, you cannot access City TV on your television. City TV can be accessed on a free-to-air digital box like the GoTV and StarTimes box. City TV, it's your world.
All right, welcome back. It's time for the docket. Now, the docket is that segment of the show where we discuss your pertinent issues that you need legal education on. And this one, today's docket says, is there any law on delivery of goods policy? Okay, with dispatch services in Ghana? Well, I'm asking because I run a dispatch company. And for some time now, we've been encountering quite a number of challenges. All right, where clients fail to pay us for delayed deliveries. All right, so a typical scenario is a time where one of our food service partners called us to deliver pizza to a client. We got there, and the client was livid because he had ordered about 2 hours ago for a meeting. He refused to pay us because he said the meeting had ended, and the people he had ordered the pizza for had left. So he did not need the pizza anymore. Now my issue is, we are just middlemen who unfortunately have to bear the consequence of a client's displeasure all the time. We have tried having a conversation with our partners, but it hasn't yielded any results. I wanted to know if there's any policy we can enforce in the partnership deals so that the other parties can take full responsibility for such mishaps. How can the law help us? This is fascinating.
That's a fascinating question.
Very fascinating.
And I wish that Clemena Kapam was here
But that's more like
to answer this question.
That's more like
but I'd like to cut this question into two. So the first one is about the restaurant. Or the person who makes the food. They may have entered into some agreement with the customer who says, okay, I have this meeting ongoing. It's going to last for 2 hours. And I need the food to refresh my guests and things like that. So that would be a clear contract between this customer and the provider of the food service. Clear contract with them. So between the two, if you deliver the food, when the program is over, it's a clear breach of contract. And a cause of action in contract law, breach of contract accrues to him, and he can sue the food service for reliefs. In respect of this middleman, and it's not clear who is refusing to pay for the service. If the person refusing to pay for the service is the client. The client may be right in doing so, But is that to say that the courier service provider is remediless? I don't think so. And it's asked the question whether there are any stated policies to deal with problems like that. I do not know of any policy, except that it's important for these kinds of relationships that the parties try as much as possible to put the relationship in beautiful calligraphy. So I'm a courier service provider. What happens if I deliver the food and the person I deliver the food to says that you, the person providing the food service yourself, you have breached the contract by not supplying the food at the time that I really needed it? Is that okay? So this courier service provider needs to enter into that kind of written agreement with a food service provider that in the event that I go and the person refuses, the customer refuses to accept the food, these are the consequences that should follow. I should not be made to bear the brunt of that breach of contract between you and the customer. So in those kinds of situations, you, the food service provider, will still have to pay me for my services. And I think there is a function of that contract between them. Unfortunately, business people in our part of the world take things like this for granted until something like this happens. But I think that, business people should begin to think more broadly about the eventualities of things like this and prepare for them in beautiful calligraphy.
Because what has happened probably is that we've been very rapidly thrust upon by the turn of events, especially since COVID. The need for delivery services sort of shot up. So then you have all these various companies who are now doing deliveries. And so people, even in my office, people don't necessarily deal with the food provider. They're dealing with the service delivery company. So they will then go to the food provider
and pick up
the food. If I order the food and get it picked up, and then bring it to the delivery point. So if in all of that,
then this configuration now is different. So let's say, is it Glovo?
Yes,
it's a very popular one.
Glovo,
so you are dealing strictly with Glovo and ordering your food through Glovo. At that point, there's no direct relationship between you and the person who is making the food. So the relationship ends with Glovo because the one you have dealt with say, can you get me these assorted items in terms of food by this time? And Glovo agrees that, we'll do that. That's no problem. That's a contract between you and Glovo, and this doesn't extend to it's possible that Glovo may have communicated with a food service provider and they may have come into some agreement as to how soon the food will be ready,
and all that.
Because of their own request. Then if there's a breach, it becomes a breach between Glovo and the food service provider.
Well, very well. So I think Kelly has said a lot. When I saw this, I was asking myself a number of questions. In real life situations, if I was having a client sitting before me, I may probe a bit further to ask questions. Okay. So for instance, we do not know the terms of the delivery.
Okay.
So it's possible that the delivery company was told by the food supplier to have delivered within a period of time. And these delivery companies, on one delivery, they do a lot of deliveries.
Yes.
It is possible that they may have caused some delay along the way. Honestly, if the food supplier was on time, but the delivery company did not deliver in accordance with the terms of the delivery period, then it raises an issue.
Yes.
And the client, the delivery company saying that the client saying they are not going to pay may be justified in some way, because you see
they prepared the food on time.
They prepared the food on time, but the delivery had an issue. And for me, this is what we call, this kinds of relationship, we call it collateral contracts. There are some contracts which require the reliance of another third party to perform.
Okay.
So like delivery service. So you prepare the food and the delivery service will go and deliver it. So at all times, I'm thinking that the delivery company would have known about the client.
Yeah.
They probably would have been in communication, because you have to call them and bring in the food here and there. So if we knew those facts, the terms of that delivery, then it would look like the client may be right in saying that, well, I don't need the food again. This is because in contracts, there are terms of a contract. Some of the terms are conditions. They are very important. They are fundamental. And there's some of the terms which are warranties. Those warranties, even when they are breached, the contract can still go on. When it comes to conditions, they go to the root of the contract, i.e., I need the food for my program. You haven't delivered it. There's nothing else to talk about. Did you get
the program has ended.
The program has ended. There's nothing to talk about. So there's a breach of a fundamental condition. And when there's a breach, the law says that you can reject the performance and sue for damages. These things do happen.
Wow. Well, I think that you definitely need to get yourself a lawyer and dig further into the issues and see whether you have a case or not. All right. Well, let's take a look at our legal trivia for today.
Legal trivia. Did you know that where a person loses functionality of his or her genital organs through an accident in the course of employment, such an employee shall be entitled to compensation of up to 85% of a sum of money equal to 96 months of earnings. This can be found in Section 8 of the Workmen Compensation Act 1987, PNDC Law 187. That will be all for our legal trivia today.
All right, thank you once again for watching A Question of Law. It's been an exciting show today. I want to say a big thank you to my guest. I had Kwesi Kelly Delata, who is a private legal practitioner, as well as Albert Kwashiga, also a private legal practitioner, as well as a law lecturer at UPSA School of Law. Keep watching City TV. We'll be back on your screens.